Good afternoon and welcome to the BRR Legal Brief, looking at the major legal issues affecting corporate Australia. I'm David Bushby and today we're looking at the future of financial advice, which was due to kick off on 1 July this year but has now been deferred. And joining us to discuss the issues surrounding the FOFA reform is Jim Boynton from King & Wood Mallesons. Welcome, Jim.
Thank you, David.
Jim, big news overnight, deferral for the FOFA reform. Can you give us the latest?
Yeah, it was due to start 1 July this year, and now it's been announced 1 July 2013 with a voluntary compliance in between times.
Well, it's certainly been, I guess, a very controversial reform, and there's been some resistance at times, and momentum was for change this year, I thought. If we can just step back, I guess, and look at the main drivers for the FOFA reform in the first place.
Yeah, so we start with the financial crisis. Some firms collapsed, like Storm Financial and Opus, and there was an inquiry. The inquiry concluded that financial planners give conflicted advice. And so as a result of that, they said financial planners must act in the best interest of their clients, and also they shouldn't receive certain types of remuneration.
And I guess we have a bill that has been reviewed. What are the main planks, I guess, for the FOFA reform? Yeah,
so the planks are three, if you like, and there's still a bit more reform to come. But what's in the bills at the moment is, first of all, we've got things around what people who give financial advice need to do if they're going to give it to retail. The second one is banning certain payments and other benefits. And the third one is expanding out ASIC's powers, because ASIC said, well, the reason why we didn't do this is we didn't have enough power.
And the reforms, or those planks, have certainly generated a lot of controversy in the financial services industry. Which of those have drawn the most argument? And secondly, are there any issues that are, I guess, flying under the radar?
Yeah, I think that the first one's drawn the most argument because not only do advisors need to change their processes to act in the best interest, but there's also this regime called an opt-in regime, where if a client is going to continue to pay fees, they actually have to voluntarily opt in and say, yes, David, you can still charge me fees. And that's most controversial because advisors have relied on annuity streams, and they've been fighting hard, and they're still fighting hard, and the opposition is saying they don't want the opt-in. So they're the most debated ones. The sleepers, I think, are around the banned payments and other benefits because it doesn't just apply to financial planners. It applies all the way along the value chain in the financial services industry.
And of course the Parliamentary Joint Committee has looked at the bill and delivered their recommendations to government.
Yes, so in February that committee reported. The committee recommended a few things, but they're not revolutionary. I think they're really playing around the edges. There was a dissenting report which recommended a lot more, but we'll see how that plays out. And then this week there was also another committee reporting, but pretty much recommending the same thing. So next step, it's in Parliament, was in Parliament yesterday, and needs to be debated and finalised.
Well, as we said, we were, I guess, full steam ahead to an implementation on 1 July. That's now been deferred. So what does the industry or affected businesses, what do they need to be doing now?
Yeah, well, they're still jockeying around what are the reforms going to be like. So there's a lobbying and a responding to draft regulations piece. But then once it's settled down, they need to do a number of things. So if you give financial product advice, you've got to change your procedures and the way you go about your business. If you're making payments or receiving payments, you've actually got to do an audit of every single payment and say, well, can I keep on receiving that? And if I can't, does the grandfathering apply? And then once you've made all those decisions, you get to the implementation phase, which is what the government has responded to, and people said, well, I actually need to change my systems, my documents. So if you build back from 1 July 2013, there's still quite a lot to do now.
Absolutely, plenty to do, and I'm sure it's a big win for the industry. We'll leave it there for now, and thanks again for your time today, Jim.
Thank you, David.
And viewers, thank you for joining us. We look forward to having your company for next week's Legal Brief.